Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. Whatever your questions are, whatever your legal questions are, please feel free to get in touch with us here at British Muslim TV. Two ways you can get in touch with us. First of all, there is a landline number there, the number that starts 01924 231 083. If you ring on that number, you're able to speak to me live here in the studio and I can discuss your legal query with you live on air. Second, a very popular way of getting in touch is to send me a message on the mobile number, which also appears at the bottom of the screen. So on that number, if you send your message through on WhatsApp or text message, I will receive your message here live in the studio and I'll be able to look at your question and then address your question live on air. Very popular method of getting in touch with us. Obviously, legal matters, sometimes confidential, sensitive. People don't necessarily want to come live on air to discuss their matters. So fantastic, easy way of getting in touch is to send us a message on that mobile number. But as always, speak to me live to have a proper discussion live on air. You can do that by ringing on the landline number, which is there at the bottom of the screen. A couple of minor points before we get going. On a live show, sometimes you come across quite complex matters. Sometimes it transpires that I need to look at your documents before I can advise you properly. So if it's a complex matter or I need to look at your documents, then I'll ask you to leave your number with the control room. I will have that more thorough discussion with you off air if need be. I'll look at your documents and then have a more thorough discussion with you once I've had a look at those documents. Again, it's a service that we provide as part of the free legal advice. So even if I need to speak to you off air, it's not a problem. It is completely free of charge. So as always, we get numerous questions on immigration law, which is absolutely fantastic. Please do keep on sending those questions in. And even today, this evening, just before we've come on today, we've already received a number of questions on WhatsApp. So fantastic, keep that going. But as always, to speak to me live, you can ring on the landline number. Let's turn to some of the questions we've received already today. And I was just looking at the questions before we started the show. Very interesting questions. First question that's come in. Let me read the question out. First question, our viewer says, my son recently got British citizenship. We are on the 10-year route to settlement. Can we switch to the 5-year route? Actually, quite an interesting question. The context for those who are unfamiliar with why the question's been posed, obviously it's an immigration law question, and it really relates to those people who have overstayed in the United Kingdom. And here it's likely that both parents, husband and wife, are both overstayers. So it's not a question where somebody is in a relationship with somebody who's British or somebody who has indefinite leave to remain. It's really a question of both parents, mum and dad, husband and wife, they are both overstayers. And there appears to be a child from that relationship and the child has obtained British citizenship. I'll give you an example. Child born in the UK after 10 years would normally qualify for British citizenship. That's a normal scenario. The question that's been posed is this, that the parents will be here with leave to remain and they would have overstayed, but based on their length of residence, based on the age of the child, it's possible that they've been given some kind of leave to remain in the United Kingdom. The problem is that the leave to remain that they've been given is on the 10-year route to settlement. So it would take them 10 years to qualify for indefinite leave to remain in the United Kingdom. And the question that's been posed is, can you come out of this 10-year route to settlement and go into the 5-year route to settlement? So it's a quicker way of getting indefinite leave to remain from 10 years to 5 years. Now, I don't know all the circumstances here, but to me, it looks like it is unlikely that you would qualify for switching into the 5-year route, because normally the people who are able to switch into the 5-year route normally would have a British partner or a partner who has indefinite leave to remain. So if you've started the journey of getting leave to remain under the 10-year route, once you've been granted leave to remain, you've become legal at that stage. If your partner is British or has indefinite leave to remain, and if you satisfy the other requirements, generally speaking, you have sufficient income and you have passed the English test, you're able to, generally speaking, move into the 5-year partner route. The difficulty, as I see it here, is that I suspect both parties, husband and wife, mum and dad, they are both overstayers. So their application would still be outside the rules. It's being granted on the basis that there is a child that is British, but one of the parents who normally would have to be British or have indefinite leave to remain, I don't think in this particular scenario that we have that. I believe, based on the limited information that we have, both parties were previously overstayers, both have leave to remain now, and it so happens that they have a child who has now qualified for British citizenship. My understanding is they would, in those circumstances, not be able to switch to the 5-year partner route because neither of them has set indefinite leave to remain or British nationality. Hope that answers your question. If you're not sure about the answer that I've given, by all means, do send me a follow-up question, or as always, you can give me a ring on the landline number and we can have a discussion in relation to this matter in more detail. But thank you very much indeed for that question. Okay, as always, we've got other questions which have come in. Let's look at the next question that's come in. Our viewer says, "Sir, I am a British citizen. I have a son who is also a British citizen. And my wife is Afghan citizen and they are both in Afghanistan at the moment. Due to the current situation in Afghanistan, my family's life is at risk, which has put me in huge depression because of my family circumstances." So unfortunate set of circumstances here. You have somebody who lives in the United Kingdom. As far as their close family members are concerned, wife and child are concerned, they are in Afghanistan. The child is British, but the wife appears not to be British. Wife appears to be an Afghan citizen, both there in Afghanistan. What can be done? I mean, to be quite honest, it would be difficult to get anything done quickly here. As far as the child that is British is concerned, it is easier to get the child to the United Kingdom. As a British child, the child would be allowed to travel, obviously subject to being able to get a flight to the United Kingdom. And there is a specific way of getting in touch with the embassy there or consular staff to let them know that you are British, and they will assist British citizens to come to the United Kingdom. The difficulty is this, and it's not relating to the child that's British. The difficulty is in relation to the partner who is not British, who is an Afghan citizen. That's certainly how it appears here. It's unlikely that the foreign and Commonwealth Office will do anything to assist her. She will have to apply for a visa to come to the United Kingdom in the normal way, because she would have to apply for a spouse visa to come to the United Kingdom. There are requirements which need to be fulfilled for that, such as the English requirement, such as the financial requirement, etc. So there, unfortunately, isn't a shortcut to this. Your wife, who is in Afghanistan, would have to apply for a spouse visa to come to the United Kingdom. Now, that presents real practical difficulties because as far as applying is concerned, if your wife is in Afghanistan, where is she going to apply? There, as far as I'm aware, currently no visa center where an application can be submitted. She would have to travel to Pakistan, which was always the case. Afghan citizens would travel to Pakistan or India and submit their applications from a visa center there, Islamabad or Peshawar or in Bombay. The practical problem now is, how do you leave the country and get to Pakistan or India? It's not as easy as before. So currently that does present a problem. Can you get out to Pakistan, to India, Iran, to one of the neighboring countries to submit that spouse application? The problem is this, that there is no shortcut at the moment for family members of British citizens who are abroad. If they would normally have to qualify for a visa, then here in this particular scenario, the wife would need to qualify for a visa in the normal way by meeting the requirements and by submitting the application using the normal channels, visa center, whichever country is convenient. Unfortunately, there isn't a shortcut at the moment. Hope that answers your question. Taking a short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring the landline number which appears at the bottom of the screen. Alternatively, as always, you can send us your questions on the mobile number that also appears at the bottom of the screen. Okay, as always, we've had a number of questions coming in. Let's look at the next question. Departing from our norm a bit, it's a question on employment law. So immigration questions, employment law questions, whatever your legal questions are, please feel free to get in touch with us on both those methods there. Okay, let's look at this employment question that's come in. Let me read the question out and let's look at what the position is. Our viewer says, I have been receiving the national minimum wage for 80 hours I work in a month. For the other 90 hours that I work in the month, I receive only £6 an hour. I am 25 years old. So this is a question, an employment law question relating to an employee who hasn't been receiving the national minimum wage. What our viewer says is that they seem to be working a total of 170 hours a month, so probably around 40 hours a week. Their concern and the reason to get in touch is that it appears that for 80 hours a month, the proper wage is being paid, the national minimum wage, and for the remainder, the 90 hours a month, it seems that only £6 an hour is being paid. So what can be done? Now, the starting point is this, that what is the minimum wage at the moment for somebody who is 25 years old? Now, for somebody who is 25 years old, the national living wage applies to them. So for each hour that they work, they have to be given a certain minimum hourly rate of pay. The national living wage applicable to those who are 23 or over is £8.91 an hour. So anybody over the age of 23 is eligible for an hourly rate of £8.91 per hour. That's the minimum you have to be paid. If you are paid less than that, then your employer is in breach of the minimum wage regulations. So clearly, what our viewer is saying here is that he or she has only been paid £6 an hour. So for every hour, there is a shortfall of £2.91. And then you've got to multiply that by the 90 hours which are being paid where the minimum wage is not being applied. So £2.91 an hour times by 90, and off the top of my head, we'll come up to a figure around £200. So every month there is an underpayment of around £200 or a month or thereabouts. Now, my calculation, let me just do that calculation again. It's £2.91 times 90, it is about £260. So it's a significant underpayment here each month. Now that underpayment obviously continues. I mean, you don't get, you're underpaid for this month. As you carry on, there's an underpayment for next month, etc. It accumulates. What can an employee do in that situation? An employee has a number of options, and I think it is, in my experience, best to take it in stages. First option is obviously raising a complaint with the employer, and you can do it informally, or I think the matter is quite serious. My view is that it's serious enough to warrant at least a formal grievance complaint being lodged with your employer. Get it down in writing. If you need to send an email to the employer and request a meeting and make it clear. Look, my concern is this, that at my age, the minimum wage is £8.91 and you're paying me £6. There is a shortfall for every hour that I work. And that's been going on for however long. It might be 2 months, 3 months, 1 year, whatever it is. Hopefully, one hopes that the employer will see sense and resolve the matter. And not only will the employer offer to pay for the shortfall for however months there's been an underpayment, but not only that, but the employer will say that, you know, from now on, the proper wage will be paid. So that's a hope, that's the aim of raising a formal grievance. Let's say the matter is not resolved. The problem continues. The employer ignores what's been said. What can you do in that situation? Well, at that stage, I think you have to take a more formal step. Obviously, the internal mechanism for resolving matters internally with the employer hasn't worked. You have to take the next step. The next step is to raise the matter with ACAS. And ACAS, my view is, use the early conciliation service. You can access that by going onto the website. Contact ACAS, get ACAS to intervene, speak to the employer. Hopefully that will resolve matters. If that doesn't resolve matters, then let's take it to the next step. And the next step is that you have to issue proceedings in the employment tribunal for all the back pay. I think you can go back around 2 years. I might be wrong in terms of limitation, but certainly you can go back quite a long period. So you issue proceedings for the back pay in the employment tribunal. There the employer will be forced to come to the table to deal with the dispute. In my experience, that normally results in the matter being resolved. Those are your three normal options: raising matters formally with the employer as a grievance, referring the matter to ACAS, thirdly, going to the employment tribunal and raising a formal complaint. There is one other option. The effectiveness of that it really does depend on how busy the organization is to whom you report your concern, and that is to report the breach of the minimum wage regulations to HMRC and to let them investigate the matter. It just depends on how busy they are as to whether they will pick this up and deal with this or not. So you have a range of options here. Obviously, you're concerned about how you're being treated, and obviously that's why you've got in touch with us. And it seems to me, based on the limited information that I have, that your concerns are legitimate, and that it does warrant you taking some steps to try and resolve it, from the grievance to raising the matter with ACAS, going before the employment tribunal, going to HMRC and informing them of your concerns. But it does look like there are certainly grounds there for you to pursue this further. Thank you very much for that question. If you're still not clear about the answer that I've given, please do feel free to contact me here live on air on that landline number. Brilliant. Let's look at the next question, an employment type question. Let's have a read of that question and see what the legal position is. Our viewer says, Assalamu alaikum, quick question on employment law. I was sponsored by my current workplace for my master's degree with the clause that if I leave within 3 years of graduating, I have to pay back. I am looking to leave within 3 years. Can they cut my wage from my last payment? What are my rights? Very interesting question. Employment law question. So our viewer is asking that they were sponsored by the employer for the master's degree that they've undertaken. So the employer would have paid for the master's degree. Let's say its typical cost is in the region of, let's say, about £14,000-15,000. So the employer's paid it. And the condition that the employer has applied is to say that if you leave within 3 years of graduating, then you have to pay the money back. And the question that's been posed is, can money be cut from my wages? A couple of issues arise here. First of all, the starting point is this, that you need to look at the clause which allows the employer to claw back the money that it's paid towards your masters, because there are circumstances in which that clause which says you have to pay the money back may be unenforceable. Now, let me give you an example. If the clause says, and this is quite general, but this will give you an idea. If the clause says, if you leave at any time within 3 years of graduating, you have to pay all the money back, that's unlikely to be enforceable. Contrast that with a situation where the clause says, well, if you leave in the first year, 100% is payback. If you leave in the second year, 50% is payable. If you leave in the third year, 30% is payable. So if it's tapered in that way, it's likely to be enforceable. So if it's just straightforward, you leave any time within 3 years, you've got to pay the money back, it's unlikely to be enforceable. So you might get away with not paying any money back at all. So you've got to, just because the clause says this, it doesn't mean it's enforceable. You have to look at the enforceability of the clawback clause. Second question that you ask is, let's assume it's all enforceable. Can they take money from your last wage? Yes, but only if your contract allows them to do that. So if your contract says that if there's any money owing to the employer, such as trading fees paid, and that can be deducted from your wages, then if that clause is enforceable and that clause appears in the contract that it can be deducted from your final wage, then yes, the money can be deducted from your last wage. So it's quite a few ifs and buts there, quite a few conditions there which need to be satisfied. So it's not that straightforward. But hope that answers your question. If you're not sure, please do come back to me. We're taking a short break. We're going to be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. As always, if you want to send us a message on WhatsApp, you can do so by sending a message on that mobile number which also appears at the bottom of the screen. As always, we've been receiving loads of questions on the mobile number. Let's look at the next question that's come in. Quite a long question. Let me read the question out and then let's look at what the best practical advice is given the circumstances that our viewer finds himself in. Our viewer says, I have a question, please assist. I came here on a spouse visa and I am not living with my wife. I still have a visa for the next few months. And I am planning to apply for a visa on the basis of my child who was born here. It's been 6 months. I've been trying to contact my wife, but not been receiving any response. What do you suggest I should apply for? Visa based on my child now, or should I apply late? For example, after 2-3 months, as it's already been 6 months. If I apply late, is it going to affect my application or not? Okay, sad set of circumstances here. Husband and wife have split up and it looks like they have been separated for a few months now. The husband's visa, our viewer who's texted in, his visa is coming to an end in the next few months. Wants to apply on the basis that he has a child in the United Kingdom. Obviously, that application is based on having contact with the child, and it looks like he is trying to establish contact, but so far it hasn't worked. According to our message, the wife has been reluctant to come forward and agree any kind of contact. Now, obviously, we don't know what's happened. We don't know the ins and outs of what's happened. But I can give you some general advice in terms of how, in my experience, this pans out. First of all, you've said that your visa is going to come to an end in the next few months. The first issue that arises is that your wife may contact the Home Office with a view to getting your visa curtailed. So what I tend to do in that situation is advise clients that they should take the first step and contact the Home Office themselves. And contact the Home Office in the sense that update your contact details that the Home Office keeps. So tell the Home Office of your new contact address, your email address, your telephone number, and your new address. The reason I say that is this, that if your wife has contacted the Home Office and asked the Home Office to curtail your visa, they will be writing to you, giving, first of all, an opportunity to explain why your visa should not be curtailed. And if they do decide to curtail your visa, giving you time, giving you notice of the curtailment, which is normally 2 months. So by contacting the Home Office and informing them of your contact details, you should be contacted by the Home Office. There is an address there where they can contact you. There is an email address there that they can write to. There is a telephone number that they can ring on, although telephone calls are not normal. So you need to be there contactable. Now, I'll look at this in greater detail after I've taken our next call for the day. Hello, assalamu alaikum.
Walaikum salam.
Thank you, brother, for calling. What's your question?
Can you hear me?
Yeah, I can hear you loud and clear.
Yeah.
Yep.
Yeah. Well, I want to ask you if I was sponsoring somebody from abroad on a permanent basis.
Okay.
Is there a limit on saving and the pay slips? How long, what sort of limit do you have on the pay slip and the bank statement?
Okay. So, sorry, I missed the first point. You were saying you were looking at sponsoring somebody on a permanent basis. Is it a family member that you're sponsoring, or?
Yeah.
Okay.
Say if you're sponsoring your wife.
Wife, I understand. Yeah. Okay. So for a wife, you need to look at whether you're going to rely on wage slips, savings, or a combination of both. So if you're relying on wage slips, you'll need to submit the last 6 months' wage slips, generally speaking, if you've been working for the same employer, which shows that you're earning 18,600 per annum. If you're, and obviously the money needs to go into your bank and you'd submit your 6 months bank statements. If you're relying on savings, again, the money needs to have been held in your bank account for 6 months. Now, it just depends. If you're completely relying on savings and not employment, those savings need to be in your account for 6 months, and it's 62,500, which needs to be in your bank.
Okay, I can't hear you. You're breaking up.
But let me repeat it. I don't know whether it's because you're too close to the TV, but if you're relying solely on savings, you need to show savings of £62,500 in your bank account for 6 months. That's if you're relying solely on savings.
No, I think I won't be relying on saving now.
Okay. Okay. What are you relying on employment or what?
Yeah, employment. Yeah. Yeah, I'm still got a job. Yeah, so
Okay. Okay. Are you, sorry, did you say you're working at the moment or you're looking?
Yeah, I am. Yeah, I'm still working. Yeah.
Fantastic. Okay.
So I'm earning 30 plus. So
oh, fantastic.
Yeah,
fantastic. Fantastic. You've got nothing to worry about. Look, the easiest way is if you're employed by the same employer for 6 months, you submit your 6 months wage slips, 6 months bank statements, and an up-to-date employment letter, not more than 28 days old, confirming you're employed, confirming your job role, confirming your salary, etc. But it's only 6 months wage slip, 6 months bank statements.
Oh, that's great. Yeah. Thank you very much. That's
Thank you very much, brother, for your call. Thank you very much.
Okay.
Thank you. Jazakallah. So, question on immigration law in terms of how you meet the financial requirement. MashaAllah, brother's on a reasonably good wage, so it does make things much easier. So let's just go back to the question that I was answering before regarding the question of somebody who has unfortunately split up from their wife. There is a child, but no contact has been established. My general advice always is inform the Home Office of your contact details so they can write to you, tell you what their intentions are. You can suggest to them, don't curtail my visa. There is a child. These are my steps which I'm taking. Or if they tell you that they're curtailing your visa, you have 2 months within which to make an application. Now, the question, brother, you're posing is this: should you wait or should you submit the application based on contact, even though really contact isn't taking place? The key thing that you need to remember is that you should not overstay your visa. Whatever happens, submit your application prior to your visa expiry. Now, your visa can expire in 2 ways. It can expire normally, naturally, whatever the end date of the visa is. Or, and I've mentioned this, if the Home Office decide to curtail your visa, cancel your visa, then your visa could come to an end much sooner. But the key point is, whatever the date is, whether it's an earlier date or a later date, whatever date is, you must get your application in before the visa comes to an end in order to stay legal in the United Kingdom. My view is this: even if contact with the child has not been established, you should still submit the application. And when you submit the application, make it clear that there are steps that you need to take in terms of going through mediation, in terms of going through the family court to obtain contact with your child. Now, what normally happens is this, that the application that you've submitted based on your child will take 6 months, 8 months to be decided. Once it's been decided, you can potentially progress your application for contact. And whether that's through mediation or through the courts, you can take active steps to establish your contact. And if your wife is not cooperating, you're going to have to see a family lawyer and start contact proceedings, because those proceedings do take a long time. The immigration application may take 6-9 months to be decided. The application for contact may take much longer if your wife resists the application. And there are certain matters that can come up which can make or prolong the application for contact even more. Could end up taking 1.5 years, 2 years, etc. Now, if the Home Office are considering the application and they find, look, our rule is you must show us a court order that contact is taking place, or you must have a letter from your wife confirming contact is taking place. We have neither here. We're going to refuse your application. They will give you a right of appeal. That gets you more time as well. So what you're doing is, whilst you've got all this time whilst the application is going on, if it's refused, time whilst the appeal is going on, you've got all this time. When you stay legal, you're allowed to continue work legally. And it gives you time to sort out contact. That's the key thing. It gives you that time to get that contact order that you need. Once you've got the contact order, you can show it to the Home Office, and that is an acceptable piece of evidence for establishing that you are in contact with your child. I mean, the easiest way would be if your wife was to simply confirm in writing that you're able to have contact with the child. The Home Office will accept that. But if that doesn't work, doesn't happen, you must then try and obtain a court order. And that takes time. And what you want to do is make sure you get your application in time. And as that application goes on, or if any appeal is given to you because your application has been refused, then whilst the appeal is going on, you try and establish your contact and get that contact order. So hope that answers your question. Normally, in my experience, these are complex matters, and I do advise clients to take legal advice from an experienced lawyer if you do find yourself in these kind of unfortunate circumstances. Hope that answers your question. If you're not sure, please do come back to me. We're going to be taking a short break. We'll be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, you can send me a message on the mobile number which also appears at the bottom of the screen. As our viewers who've been following today's show will be aware, we had a question regarding employment law from a brother who was saying that he is employed by a company which has sponsored his master's course. So the master's course has been paid for, and the issue is that if you leave within 3 years, the money will be deducted. I'm going to come back to this, quite an interesting question, but we do have a caller on the line, so let's take our next call. Hello, assalamu alaikum.
Wa alaikum assalam.
Ji, thank you for calling.
Can you hear me, yeah?
Yeah, I can hear you live. You're live on air. I can hear you loud and clear.
My question is, I came in 2010 as a student.
Okay.
And in between, 2013, I applied for extension, and my extension goes delayed by Home Office for the result of what the answer for my application for extension, they're gonna give me visa or not. But after about 1.5 year, in 2000, I think 15, yeah, I got married with a British girl, and in between this time, I didn't get any letter from Home Office or anything like this. But I got a visa on my babies after 2 years, like a 1 year time. We got baby, and I applied for legal status in the United Kingdom, because I was student before, and being to solicitor, he told me you have to do these things. My question is main to the point. The main question: I got the visa, yeah, but in the last from 2010, yeah, they put me again on 10-year route, 10-year route from 2019.
Understand? Yeah.
So, is there any chance to cover this period with my this 2.5 year more as well, for
Okay.
applying for indefinite?
Okay. So when you came in 2010, 2013, you applied for an extension. 2015,
Yes.
you got married. It looks like during that time your visa might have come to an end, as in they might have issued a decision and refused your application at some stage. So did you, from your recollection, did you become an overstayer at all around 2013, 14, 15?
I was on the same address where I applied for the visa, yeah.
Okay.
But I didn't get any letter from Home Office. I was
Understand.
waiting for my result. They're gonna give me visa or no visa.
Okay. Understand. Brother, you know what you need to do is make a subject access request. I don't know whether you've done it already or not. You make a subject access request from the Home Office to get your file, electronic file from the Home Office. Because what you need to look at when you get the file is, have you been legal since 2010 or not?
Yeah, I was legal in 2010.
We're not sure now. That's why if you were legal from 2010 and you've remained, your residence in the UK has remained lawful, there's been no break, you've applied in time, they've taken time to consider the application, but it's never been the case that your visa has expired. Everything's been done on time. Then you've completed 10 years of lawful residence in the United Kingdom. So you qualify for indefinite leave to remain now. However, before you take that step, what I would suggest is you do get a copy of your file from the Home Office to see what happened in 2013, 14, 15. If there's been no break at all, then you qualify for indefinite leave to remain now. If there has been a break, then what you look at is, okay, when did you become legal again? Did you become legal again in 2015, 16? That's where you count the 10 years from. Does that make sense to you, brother?
I can't hear you properly. Sorry, I do apologize. Your voice is reaching to me, but just like missed.
Okay. But the key thing is this, the most important thing is this: you need to request a copy of your file from the Home Office. So it's a subject access request. You need a copy of your file to see what's happened over the last 10 years. That's the starting point. Because if you have stayed legal for 10 years, you qualify for indefinite leave to remain now because you've done 10 years in the UK.
Okay.
If in 2015, 16, your visa came to an end, you've overstayed, then your 10 years will start from when they granted the new visa to you, whenever it was. So, but you won't know this. You need to get your file from the Home Office.
First, all right.
That is the starting point. If you get your file from the Home Office, you make the application online, subject access request from the Home Office, you make the application online, you've got to then show it to a lawyer, an immigration lawyer. He or she would be able to tell what's happened. The key thing is what happened in 2013, 14, 15, 16. What happened in that period? That's what you need to
on basis of this file which I get from the Home Office.
Yep, you can tell from the file. You can tell.
Okay.
Straight away you can tell. Any experienced lawyer looking at the file will be able to tell you straight away what's happened. When can you apply for indefinite leave? They'll tell you the date based on that.
All right. Okay.
There may be other options there. There could be another option. Okay, you're on the 10-year route. You might be able to go into the 5-year route now. But we need to look at your file before a lawyer can advise you properly.
Okay.
Okay. Subject
Okay, thank you
access
very much.
request.
Yeah.
Okay.
Yeah, I will get the access for my file as well.
Okay, brother. Thank you very much for your call.
Thank you very much. Thank you very
Jazakallah.
much.
Thank you. Thank you. Interesting question. We have another caller from Birmingham. Let's take our next call. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum.
Ji walaikum salam. Brother, thank you for calling.
I just asking because actually one of my friends, and he's actually I met her like about 20 years ago. Then I was told like she gone back like whatever she fine, but she was still here, and so I 2 years ago again that she was on the street. So like she was a Muslim, and somebody from Kashmir, India side, and she's slave with them, and they beat him up, thing like then kind of she was. I saw she was crying and crying, and she was thinking like Then I was told like as a human right, like my home, I give the food, everything, clothing, everything, but not better. She's recovering now, and she don't know where come from, and is from India side.
Okay.
But that time she was 50 years old, and they picking them from the people like from mafia, from Hindu guys,
Okay, all right.
And
Okay.
then they bring him up. I don't know how they pick him up here for slave, and they ask him to do a bad thing, and she run away.
Okay.
And some people like everybody who's a Muslim or any Christian or whatever.
Okay.
She was very innocent, like they give them food, everything. When I saw them, like say, okay, I can help to her.
Okay.
Then what I would say, like at the moment, she look after I'm 65 years old. After me as well, and also she cook for me, and she's also I give them as well, and she get account on her name, and she get also doctor is before she didn't have any doctor, no account, no nothing.
Okay.
But she had some say. I have some effort. I'm married, but not the divorce. I want to keep her partnership. Muslim as well by law or British.
Okay.
Because I had a previous year. I don't want divorce to her.
Okay.
And we are Muslim law, but but as a part, there's Islamiyat.
Okay.
And I want to keep her like it.
Okay.
Because she got nobody.
Okay, but the main thing is this, that you've described a set of circumstances which are quite worrying. Normally, and I don't know what's happened so far, normally you'd need to point her to an organization that can assist her, whether it's the doctor that she goes to see, or whether it's a Citizens Advice Bureau, or whether it's social workers. Obviously, given the set of circumstances you've described, the key thing is that she needs to be referred to an organization that can assist somebody who has faced this kind of situation. And it may well be that they are able to assist her. Brother, that's the key thing here, that she is referred to the right organization for assistance. That is the first step, to refer this lady to the right organization, and make sure that she receives the help and assistance that she needs. But that's the key thing here. I think the other matters that you described, I think, do come later on. But thank you very much for your call. We've got another caller on the line, so let's take our next call. Hello, assalamu alaikum. Oh, sorry, I do apologize. I thought we had another caller waiting. Look, we've had a number of questions coming in, and there is a question that I do want to answer, which is the employment law question. A brother who called in about the master's course he's been doing, sponsored by the employer, and the employer is saying, if you leave within 3 years, you've got to pay the money back. The clause says, you will be responsible for reimbursing the cost of the course if you decide to leave your employment within 3 years of completing the course. The whole money has to be paid back. That's what it's saying. I think that is not enforceable. I would take advice from an employment lawyer. I don't think that is enforceable, because they want the whole money back whenever you leave within 3 years. It's not tapered. I think that is not enforceable. Any fees owing will be made by way of an adjustment in your final salary. If the value is greater than your final salary, you'll be required to repay the full amount after the termination date. The starting point is that clause enforceable where it says you will have to basically pay all the money back if you leave within 3 years. So it's not tapered at all, that if you leave in the first year 90%, if you leave in the second year 50%, etc. You're just saying anytime you leave, you pay the whole amount back. My view is it's not enforceable. There's a lot of case law on this, and I would say to the employer, it's not deductible. If they do deduct, the problem is this, if they do deduct, you as an employee initially can't do anything when they deduct the money. You can't do anything because they've got the money. But what you can do is, if it's an unlawful deduction, you can take the employer to the tribunal. So there is something that you can do. If they deduct, tell the employer what your position is now and take it from there. Unfortunately, we are running out of time. It's an interesting question. I'll be back next week. So if you do want to send me any follow-up questions, you can do that next week. Inshallah, we'll be back next week. See you then.